This is our PowerPoint and YouTube lecture on Chapter 2 for Human Resource Management, and this is my area of expertise. I want to mention that the book is an overview of various federal and state laws that protect workers and classes of workers. I don't want to just read to you those laws, so we're going to just hit highlights in this PowerPoint, maybe some areas where you might find more risk, and to be aware of those areas is a cure, I think. A way of preventing the problems is to know where the risks fall. Here we're discussing on the first PowerPoint the various federal and state laws to protect workers and classes of workers against discrimination based upon age, color, disability, marital status, genetic information, military status, and so on. There is a lot to unpack here, and again, as I said, I'm not going to read them to you, but I do want to point out in the next slide a way to understand this. First off, the rule of thumb is if it's not related to the job, don't ask. Leave that information outside. Don't let supervisors inquire. Don't put it into your records if it's not related to the job. From that, if there is a question that arises with regard to how the company treated the employee, there are two ways the courts look at analyzing this problem or question, and that is on the next slide. First off, the courts are going to be looking at disparate treatment, which is a specific type of discrimination, meaning that in an individual case, there was discriminatory practices. Here, for example, it might be that a supervisor said that you're too old for the job or you don't look the part for this job. There could be statements from the management that would indicate there was specific discrimination. The second area to answer this question that the courts will review is the disparate impact. This is often by attorneys referred to as statistical discrimination, which means that in a large sense or a statistical average, there was discriminatory practices. Not that there was a particular case of an individual, but overall, the whole of it, there was a practice that the federal and state laws ban. So again, here we're looking at data that would indicate trends, percentages of hires. For example, if I find that an employer hires only within a certain age group and eliminates ages 45 to up, which is a protected class, or eliminates the case of African Americans, which is a protected class, then I would say, statistically speaking, the employer is engaged in unauthorized and illegal, unlawful discrimination. I had a particular case where an individual came to me. He was let go. He was basically laid off with 7 other employees. Within 2 weeks, though, the 7 employees, he was the 8th, the 7 employees were rehired. Turns out that he was the only African American in the 8 people let go, and he was not rehired, whereas the other 7 individuals were rehired. So even though nothing was said to him individually, we would call this disparate treatment or specific discrimination. And it might be that there's a pattern or practice in that firm. So we would go back as attorneys and look sort of digging into the layers of the history and try to find where other individuals as a whole were impacted based upon unlawful discriminatory practices. So again, I'm not going to lecture specifically over these. These are for your reading. I do want to mention towards the end here that there is a discussion in the book about training. In other words, it might be that the employer is liable for a particular or a statistical practice of discriminatory pattern or discriminatory practice actions and they might want to distance themselves. The firm might want to distance itself from that bad practice by using some form of training, by putting in the individual, the manager, or someone in some type of training program to rehabilitate that individual, so to speak, and show in good faith that the company is not engaged in a pattern of unlawful discriminatory practices. So training is sort of a cure that employers use to distance themselves and to also, I would say, penalize, but certainly to correct the employee's bad behavior. I want to mention that training is a common cure or remedy, but it is not a guarantee. And that's something the book does not mention. An attorney working for a disgruntled employee who files an action for an EEOC violation is not going to just simply agree with the employer that the training cured the problem. Trainings often are not themselves sufficient. Trainings are often simply a band-aid to the problem. So again, take a look at these and review them for yourself. I look forward to your questions.